Hey everybody. Okay, or myself, because this is for me. Okay, so this is for Cochran's criminal law class, and this is the outline he gave us today. So I'm going to read it for my own help in being able to just listen to it over and over, and that way I'll get it, and all I'll have to do is get the deeper concepts. So, video number 1. This is the basic elements of a crime. And so we're all familiar with elements already. Just a disclaimer, if you're watching this, if you're not in Cochran's criminal law class, this is not going to be helpful to you. And I'm not teaching you criminal law. I'm just teaching to his outline for my own benefit. Okay, so it goes in basically a logical order, and it's very similar to our torts elements that we did last semester. So the actus reus is a wrongful act. And so the first element, it needs to be a voluntary act, and that's willful behavior. And then you need to look for cause and fact. And you only need this if it is not a conduct crime. So a conduct crime would be like drunk driving. So there's not an actual victim, but there is a social harm. And we'll go through that with some of these other things too. So for crimes that are not conduct, you need cause and fact, proximate cause, and a harmful result. But for a conduct crime, you're saying that it is the social harm of doing that and having that conduct. So you're not going to look for cause and fact, proximate cause, or a harmful result because you're looking at the social. Anyway, and then sometimes some crimes will have attendant circumstances, and attendant circumstances are if the statute has like a qualifier. So like breaking and entering at night, the at night would be the qualifier for that particular crime. And then you need mens rea, which means a guilty mind, which is kind of like our intent element in torts. So intent at the common law reading. So if you see intent, it means purposely and knowingly. But if you see malice in the common law, then that pertains to purposely, knowingly, and recklessly. And that is also the default. So if a statute doesn't say what type of mens rea it needs, then it's going to be purposefully, knowingly, and recklessly. There's also negligently, but it will say that. There's also some strict liability, which we'll talk about that in another location, and then in some cases they'll have specific intent, and that's like breaking and entering with the intent to commit a felony. With the intent to commit a felony would be a specific intent. You have an intent to do more than just what you're being charged with. Okay, so going a little deeper into the basic elements of a crime, we have a voluntary act, and that means it's conscious and willful. So an act that is not voluntary doesn't count. So if it's a reflex, if the defendant is unconscious, asleep, or under hypnosis, no voluntary act. And then we have an omission is not an act unless there is a duty to act based on a statute. So, or a statute, a status such as a parent, a contract, or a voluntary assumption. So if you voluntarily agree to take on to do something or not to do something, then you have committed yourself. All right, then we have the social harm element, and this is what is harmful, that what harm has come from that, and unless it's a conduct crime. But for a conduct crime, you could say that society is harmed by people being drunk in public or whatever the case may be. And then you have attendant circumstances, and these are, as I said, additional requirement, burglary at night, And then you have the mens rea element, which we just talked about, generally stated in a statute in common law definition of a crime. So purposely, knowingly, recklessly, those are subjective. So that's why they're our default. Purposely means conscious. You consciously went and did it purposely, because that's a word, so don't define a word with a word. Then you have knowingly, and this is particularly certain of a result. And then you have recklessly, and that's conscious disregard of substantial unjustifiable risk. And then you have negligently. So negligently is objective, and it says you should be aware of substantial unjustifiable risk, and it's a gross deviation from a reasonable person standard. So the default culpability required is generally purpose, knowledge, and reckless, if not otherwise stated. And then transferred intent to cause a crime to one, but causing the same crime to another. So the intent may be transferred, but only same crime to same crime. Okay, then we have general intent. So general intent, the culpability required as to the actus reus, the voluntary act of the crime. So that's like battery, intentional contact with another. That's the general intent of the crime. But then we have specific intent, and specific culpability required. So specific intent is the specific culpability required as to one aspect of the crime. So burglary with the attempt to commit a felony. The specific is it's not just burglary, it's with intent to do blah, blah, blah. Sale of stolen goods, knowing that they were stolen. So you're selling stolen goods, but to make that, the specific intent is knowing that they were stolen. Then we have willful blindness, and this is equivalent to knowledge of the relevant fact, if depending on the jurisdiction. So the defendant knows to a high probability and takes a deliberate action, so they know to a high probability that someone is under 18, and they take deliberate action to avoid learning the truth. That was the stripper. Hypo? No, I think it was an actual case. And then other jurisdictions reject willful blindness as a form of knowledge. So if you knowingly didn't know, then you know in some jurisdictions. So you got to know both. Some you have to take a deliberate action to avoid learning, and then others, deliberate blindness is a form of knowledge. And then we have strict liability, and this is rare, but factors suggesting strict liability if required, culpability not explicit. So this strict liability means it happened, so you're on the hook. And that is, and things that are generally those type of crimes in criminal law have minor penalties, so maybe a small fine, generally not prison, although we did have a case about that. Public welfare offenses, so pure food laws, traffic tickets, work safety. And then we have conduct likely to be regulated, so dangerous conduct. So this could be possession of a hand grenade. And then you have a regulation of trade and industry. And then another one under strict liability is statutory rape. It's well established, and strict liability offense, though it does not meet all of these criteria, because obviously there is it's not a minor penalty, and states have different statutes about what it means and what they find. So we have mistake. We also have mistake of fact, and there's no excuse for a mistake of fact. So this was the man who took the boards because he thought they were abandoned property. It was a mistake. The fact that they were not abandoned, that was a mistake of fact. So it needs to be a specific intent crime. So if it's good faith, which means a genuine mistake of fact, even if unreasonable, as to the specific intent requirement. So if it was a genuine mistake of fact, even if unreasonable, you're going to be okay. The general intent, a reasonable and good faith mistake of fact as to the general intent. So that's something I'm going to look a little more into because I don't feel this is super clear. And then we have mistake of law. No excuse unless there is reliance on an official statement of the law. Some states, New Jersey, recognize mistake of law excuse where defendant diligently seeks to ascertain the meaning of the statute and in good faith or reasonably concludes that his behavior is legal. So you have to make a good faith effort to ascertain the truth. And then duty to act statute plus unusual requirement, not likely to trigger awareness of a duty. So the duty to, so this was the woman who was convicted of a felony somewhere else, and it was like a statute in California that you had to register if you were a felon, and that's not something that like she would just know or that would just come up, and so she didn't register, and that was a mistake of law. It was she had a duty to do something and it was unusual, so like why there would be no notice of why she had to do that, so it's not likely to trigger awareness of that duty, so it's an excuse. And then specific intent, good faith mistake as to specific intent. So then we have some of our two more elements. So cause and fact, but for. The defendant's act must be a cause and fact of the harm unless it's a conduct crime. And cause and fact is established by generally the but for, Coach likes without which not. And the test is, but for the defendant's wrongful act, there would have been no harm. And so one of the ways that we can find this, which is very rare, is the substantial factor test. And that's if two factors have and we'll use murder because it's easy. So like two things, you get shot in the head and you get shot in the gut, and the bullets hit you at the same time, and they would have killed you independently, and now we can't extract what caused the harm, and so either would have independently caused the harm, so it's substantial factor test. And then we have in homicide cases, if D's act accelerates V's death, it is a cause and fact. So someone shoots you in the head, that doesn't kill you, but you've got like an hour to live, or you're gonna die in 15 minutes, and then someone shoots you in the neck, and now you die, and maybe it grazed you, and that wouldn't have killed you, but it makes you die 5 minutes faster. That's acceleration. This is so lovely, isn't it? And then the last thing we have, no, not the last thing, but the last element we're gonna talk through is proximate cause. And the proximate cause factors are different in Crim than they are in torts. And so I made this, we're going to use fade, no, you can't see that, fave doiv. I might change that. This is just the first video. So FAIVDOIV. So fa'iv duiv. Fa'iv duiv. And those are our fa'iv duiv. So that means foreseeability. That's the one you're mainly going to do. Foreseeability, move on. But if not, then you have the apparent safety doctrine. So if a victim got to apparent safety, then they say like that can be the dividing line between what the D's liability. Intervening factor, this is based on timing. So the responsive intervening factor, V, avoiding harm, rescue, negligent medical personnel. If it's a response intervening factor, excuse me, proximate cause will generally be found because it's responding to what the defendant did, and usually the defendant will be on the hook for the cause. And then you have coincidental intervening factor, and that is the victim is in a roadway, hit by a car. Okay, so you're in the country. This is not a busy road. The victim's in the road, and then a car that's never there hits them. But if it were in a busy, like PCH, that probably wouldn't happen. If the intervening factor is foreseeable, then there will be proximate cause. If it is not foreseeable, then there will be no proximate cause. So for this one, it's yes, yes, no, no. If it's foreseeable, it will be a proximate cause. If it's not foreseeable, it will not be. If the factor didn't have anything to do with D's conduct, no proximate cause if unforeseeable. Okay. And then we have the victim's contributory negligence. This is rare, but it is considered a factor sometimes. We have de minimis causes are not PC. So these are like if you shoot someone in the head and they are going to die quickly, and then you skin their elbow, like that. Okay, so maybe they lost another second because they lost that blood. But anyway, so de minimis, minimum. And then you have omissions of a third party. This could be a failure to rescue, even with a duty, are unlikely to supersede. So this is maybe like a mother leaves her kids home alone and one strikes the other and causes death. Maybe the parent's on the hook for not watching them, so an act of omission, but that's, again, rare. Intended consequences, unintended manner, poison, intended nurse to give it to the victim, but a child gets it instead. That can establish proximate cause. And then the victim's free, deliberate, informed intervention may cut off D's liability. So like the drag race case, the victim was free, deliberate, and informed. Okay, so lastly for this section is the rules of statutory interpretation. And that's just like what you do when you see a statute, and you're trying to like figure out what it means. So you're going to look at the intent of legislature and the key, what was the intent, why was it there. Then you're going to look at the common law background and may serve as a basis for implied requirements in the meaning of terms. And then the statute, you're going to read it as a whole and different language, see if different language suggests different meaning. Then you can look at the legislative history, because that might explain more. And an ambiguous penal statute should be interpreted in favor of the defendant. We did read a case on this and it was not interpreted that way, so that's lame. That was the peace officer with the gun, and it was also a mistake of law case, but they did not give him the benefit of the doubt. So that is what we've done in Crim the last 5 weeks. Good luck nailing it down.